Professor, you're on leave from the faculty at Virginia Law, are you not?
I am, Senator.
One of your colleagues, Professor Paul Stephen, tells me you are a rock star.
That is very kind of him to say that, Senator. Professor Stephen is a wonderful person.
I went to law school with him. He may be the smartest guy I've ever met. He deserves to be on the federal bench, frankly. I've been listening to you carefully. You don't sound to me like you're much of a politician. I like that. I'm going to ask you a couple of questions. I want to stipulate up front, Professor, you're going to follow precedent. And I know you've been coached. I'm not blaming the Biden White House. The Trump White House did it to, coach all of our nominees to just say, we're going to follow precedent. I think you'll follow precedent anyway, but I'm not going to ask you to tell me how you decide a case. That would be unethical. Might be illegal, but it'd be unethical. But I do want to know how you think. Let's take a new right. I'm not going to try to talk to you about the relationship between a fundamental right and a suspect classification, because you'll beat me on that one. But we both know that they both used to create new rights. Let's take wealth as a suspect classification. Do you think heightening the scrutiny of wealth as a socioeconomic policy is a decision for the voters through their legislative body or the courts?
Senator Kennedy, I believe the Supreme Court has already confronted the question of whether wealth is a suspect classification.
I know.
And that they concluded...
Rodriguez, but they could, once again, I'm not talking about, I know they said no, but I'm just asking you to put your law professor hat on.
Well, so I guess, Senator Kennedy, I think that the Supreme Court, in deciding Rodriguez, has essentially said that it is a matter for the legislature, not a matter. As a lower court judge, I would follow that guidance from the Supreme Court.
Okay. We know, you've probably taught it, we know that the right to use contraceptives is a penumbra of the, you correct me if I'm wrong, First, Third, Fourth, Fifth Amendments to the Constitution. Now, you don't find the words right to use contraceptives in the Constitution. And I personally think people ought to have the right to use a contraceptive, by the way. But we know that right was found as a penumbra of those amendments in Griswold v. Connecticut. But we can't see it in the Constitution. Is that a pretty fair statement?
Senator Kennedy, I would agree that the word contraception is not in the Constitution, and like you, my understanding is that the Supreme Court decision that recognizes that right is Griswold versus Connecticut, yes.
Okay. Are there other penumbras that we can't see?
Senator Kennedy, I'm not aware of any Supreme Court decision other than Griswold that used the specific word penumbra.
Welcome back, folks. Today's spotlight takes us into the heart of a Senate Judiciary Committee hearing. But not just any hearing. This one's packed with insight, legal philosophy, and a few moments of good old-fashioned John Kennedy charm. When a U.S. Senator who's known for his wit and no-nonsense questions meets a law professor who's been called a rock star in legal circles, sparks are bound to fly. So let's dive into this sharp exchange and break down the deeper meaning behind their words. Senator Kennedy kicks off with something unexpected, a compliment. "You're a rock star," quoting another professor. The nominee is humble, but don't let that calm demeanor fool you. There's serious brain power here. You can feel it from the first few lines. This is someone who lives and breathes constitutional law, and Kennedy knows it. He isn't there to trap the nominee, he's there to test the mind.
Specific word penumbra,
Do you think there are other penumbras out there, lurking out there, that we can't see?
Senator Kennedy, I'm not sure that I think there are other penumbras out there that we can't see because, as I think I've said, I think the only time the Supreme Court has ever used that specific word is in Griswold versus Connecticut. The Supreme Court has, for at least 130 years, concluded that the Constitution protects certain rights, such as the right to marriage, the right to travel, the right to raise children, that are not expressly set out in the text of the Constitution.
Professor, I don't really care about your politics. I care about your intellect, which is, I think, pretty well established. I care about your analytical abilities. I care about your integrity. And I care about your understanding of the role of the judiciary. And some of the nominees that have appeared before us, I believe, see their role as a federal judge to try to rewrite the Constitution and or our statutes every other Thursday to advance a social agenda that they can't get by the voters through their elected representatives. And I don't agree with that. I don't get the impression that you're like that. I'll give you the last word.
Well, thank you for that, Senator Kennedy. I think the role of a judge is very important, but
So what do you think? Should judges read between the lines of the Constitution or stick strictly to the text? Drop your take in the comments, and if you're into deep dives on American law and politics, hit that like button and subscribe for more. Thanks for watching. Until next time, stay curious.